Welcome to Notable Approvals. I am attorney Amanda Shaffer. We have a very exciting case to get to today. This is actually going to be another case that ends up being a two-parter, but there's so much here and this client has waited so long that I really wanted to talk about the first part of the case today. Before I get to it, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you're watching, so you don't miss any of our lives. And if you find this video helpful or any of our others, please hit that share button so we can get that good information out there. So today's case is about a client who is a native and citizen of Trinidad and Tobago. And this is quite the fact pattern, so bear with me because the facts here are actually really important. On Instagram, we got some weird color issues going on. Oh, fixed it. Perfect. Okay, so this client entered the U.S. in 2000, the year 2000, with a B2 visitor visa. And in 2005, so she never left the country. And then in 2005, she met a U.S. citizen, and she ended up marrying him in 2007. Shortly after they got married, she got her conditional green card, which is valid for 2 years. And like, unfortunately, so many other cases I've talked about, where when you talk about domestic violence in these situations, you can look at a timeline, and I can point out to you different times in a relationship when the abuse starts, and we have that here. Because once she got the conditional green card, that's when her husband became verbally abusive. And this is when she also found out that he had a substantial history of drug and alcohol abuse. And like many other victims of domestic violence, she thought, and people who have a loved one who's a drug or an alcohol abuser, she thought that things were going to get better, and she stayed with him. Unfortunately, it didn't get better, as it rarely does. But they were still together. And in 2009, they jointly filed the petition to remove conditions on residency, or the I-751. That's what you file in the 3-month period before that 2-year green card expires. So they filed it together. They were still together, even though they were having problems. And then in 2010, they were called into their I-751 interview, and her husband had been up the night before drinking and, smoking. And basically, the interview was early in the morning, and he was not very coherent at the interview. So needless to say, it did not go well. And because of that, after the interview, unfortunately, the verbal abuse turned into physical abuse. And that was when she finally realized, maybe not realized, but was finally able to leave him. And that's when she first started looking for legal help. And like so many of you out there, you might not know this either watching, that there is a major difference between a paralegal and a lawyer. And if you don't know the difference, you can get yourself into some trouble. Now, this client thought the only difference was paralegal couldn't go to court. That's not true. Paralegal cannot give legal advice. So there's something called notarial fraud, if anyone has heard of that is rampant out there, unfortunately. Make sure when you go to hire someone, especially, by the way, these paralegals, it's not like they're that much cheaper. They charge a lot of times the same amount that lawyers charge. So if you want to know if the person you hired is a real attorney, you go to the State Bar Association website, or you can call them even. You type in the person's name and they should show up. You can also ask them for their bar number, because we all have bar numbers no matter what state we're in. And you should be able to, you can find them by the bar number. So you can check, and I very much recommend that if you have any reason to doubt that the person's an attorney. You come to my office, you can't see it on the video, but I have my law degree and my bar licenses, and actually has the numbers on there. And you can look up my name and you'll find me in New York and in New Jersey registered. So big warning sign for all of you out there. If you're thinking you might save a few bucks by going to paralegal, it's not going to be worth it, because this story has just begun. So as I said, the abuse turned to physical abuse in this case, unfortunately, and the I-751 was denied. And someone referred her to this person that allegedly worked as a USCIS officer, who she was told has helped other people in her situation before. And granted, she should have known from the beginning something was a little shady, because he refused to meet in person. He said he was going to get someone to sponsor her, and file a new I-130. And he told her, reassured her over and over again that it was perfectly legal. And the thing is, she really, the entire time, was not trying to pull one over on immigration. She wanted to do it the right way, but she did no idea what he was doing. She's told this guy works for USCIS, he knows what he's doing, and she said, okay. A few weeks after that, after he had filed this I-130, she got put into removal proceedings or deportation proceedings. And that is very common after an I-751 is denied, that you get put into deportation proceedings. So she told him, she gave him a call and said, I have court in February of 2011. I know you can't represent me. What, do I have to go? What do I do? Can you get me a lawyer? And he said, don't worry, you don't have to go. You don't have to go, because you have this I-130 pending. And he's like, I'll even send the lawyer to court for you, but don't worry, you don't have to go. And he even said, look, you're going to get in the mail a order of removal in absentia, which means that you're deported because you didn't appear in court. And he said, don't ignore it. You don't have to worry about that. Which, that is not true for anybody. If you're told to appear in court, you appear in court, period. You can have an attorney, of course, but you can't, for a lot of court, immigration court especially, you can't even have the attorney just appear for you. So, that's another thing. Make sure that people should know that you don't want to get these outstanding deportation orders. That's pretty bad. So I do have to consult my notes because of all the facts here. Shortly after that, the I-130 package was rejected. And this was the first time that my client was able to see what this alleged USCIS officer filed for her. And she noticed that it said the petitioner was her brother. The U.S. citizen petitioner was her brother. And he was from St. Lucia. Well, she's not from St. Lucia. She's from Trinidad. And I don't even know if she has a brother. I don't remember. But it wasn't her brother. So she said to the lawyer, well, why did you do this? Oh, sorry, not to the lawyer. Oh, I'm getting confused now, too. She said to this alleged USCIS officer, I don't have a brother from St. Lucia. I'm not even from there. And he said, don't worry, I'm going to get you a fake birth certificate that lists his father as your father. And she said, all right, I'm done. And she was like, I'm not submitting false documentation. That was the smartest thing she's ever done, because if she would have submitted that, there would have been they would have known, and there would have been a lot bigger problems that she was going to face. Although, trust me, we're still in 2011. It's a very long road here. So after that, she's like, okay, I can't resubmit this I-130. I have this order of removal. I don't have a pending I-130 because it was rejected. I need to go. I need to find legal help. Again. So she went around looking for legal help, and in April of 2011, she was referred to an attorney, a real attorney. And she explained to the attorney that she had this in absentia order from a few, at that point, it was less than 90 days ago, that She didn't appear in court because this guy told her not to appear. And this attorney didn't ask her any questions about what relief from removal she would have. He didn't ask her, and I'm going to go through this a little further down about what he should have asked her, because we're going to be peeling back the onion here. There's a bunch of different layers that she went through here that I had to go through in this appeal or motion to reopen with the Board of Immigration Appeals. But basically, for now, we'll just say he didn't do what a competent attorney would do in that situation. He filed a motion to reopen the case within the time limit, but he didn't include any of the stuff that he was supposed to. Actually, I could talk about that now a little bit. He filed the motion to reopen based on ineffective assistance of counsel, saying this person that she had hired acted like an attorney, gave her legal advice, which was wrong. She acted on that, and otherwise she would have appeared. However, we have something called the Lozada requirements, and this comes from a case, Matter of Lozada. It's now an older case, and the Matter of Lozada is where the court basically says, these are the steps that you need. This is what you need to show us if you're going to get your case reopened because of ineffective assistance of counsel or overturned on appeal. And first, you need to have a statement and any evidence that you still have detailing the agreement that you have with the attorney. And I should first note, this only applies to attorneys. So someone engaging in the unauthorized practice of law, you still have to actually follow these, but it's a little different, and we'll get to that. So you're supposed to say, okay, I hired the attorney to do X, file an I-130, represent me in court, whatever it is. And you have to sign it, get it notarized, and all of that. You then have to notify the attorney that you have this complaint against them. And all that's simple. You mail it with a read receipt. And you give them an opportunity to respond. They might respond and say, that's not what you hired me to do if you didn't have a written agreement. Like, in all my years of doing these, very few attorneys reply to them. And the couple have, and they've said that what the client said isn't true. And that's their response. And you have to put the response in. And then you have to then either file a complaint with the disciplinary committee, whether it's the Board of Immigration Appeals or the state bar. And if you didn't file a complaint, you have to explain why. And then the last piece of the puzzle is you have to show you were prejudiced by your ineffective assistance of counsel. And what that means is that you have to show that but for the attorney's bad advice, you would have been entitled to some form of relief or removal. So if the attorney had done his job correctly and gotten her case reopened, she still has to show that she's eligible for relief from removal. Now, if you recall a few minutes ago, I just said that all he asked her about was kind of what happened with missing court. He never asked her about her relationship with her husband, what was going on. He never made sure that she was even eligible for relief from removal, because you can go through all those steps and she may have been given wrong advice, but if she's not eligible for any immigration benefits, it's not going to help. So she files, or the attorney files the motion to reopen in May of 2011. I'm sorry, in April 2011. And then he tells her in May 2011 it was granted. And you have court in June 2011. So she goes with him to court in June 2011. He tells her to wait in the hall. He goes in and he comes back out and says, your motion to reopen was denied. And she never saw the judge or anything. And she was obviously confused because she went to court that day because she was told it was open, but he wouldn't explain it to her. And everyone who's watching right now knows how much I explain things, whether it's in my notable approvals, and if you're a client of mine, You know that I take extra time to make sure you understand what's going on, especially if we lose something and have to do something more, which we rarely do. I want making sure clients know what's going on and what's happening with, and understanding what's going on is one of the most important things to us here at the Shapiro law firm. So he never explained to her what happened, and then he stopped taking her calls. So she immediately, and this is all, and keep remembering that I'm saying immediately, that this client did not at any point sit back in all of these years and do nothing. And that's very important, and we'll get to why. So she was referred to a second attorney in July 2011, and she had a similar type of conversation. This attorney said, all right, let me first see what happened. So this attorney found out that what ended up happening with the motion to reopen is it was granted, but then the Department of Homeland Security filed a motion to reconsider. Thank you, Sherlyn. Very transparent. I can't read the rest of it's blocked now. You will be very well informed. Yes, that is very true, Sherlyn. Thank you. That's our goal here. So she goes to the second attorney, and the second attorney says that the Board of Immigration Appeals filed this motion to reconsider because it was granted because the judge said, well, the DHS, the Department of Homeland Security, didn't oppose the motion. And the Department of Homeland Security said, yes, we did. We did file an opposition to not reopen the case because they didn't follow those other requirements. So the immigration judge actually granted their motion to reconsider the reopening of the case and then denied the motion to reopen. So I'll say that again because it's a little confusing. A motion to reopen the deportation order was filed and granted. Then, just like any other order, if there's a possibility that an appeal or a motion to reopen or a motion to reconsider can be filed. And the reason it was granted initially was the judge wrote that there's no opposition from DHS. When DHS got the order, they said, wait, we did file an opposition. Here's our copy. We are opposed to reopening it because she hasn't proved what she needs to prove to reopen it. So then the immigration court agreed with DHS and granted their motion to reconsider their decision to reopen. And when they reconsidered their decision to reopen, denied to reopen. So this attorney explained that to her and then said that, okay, we're going to get a signed statement from you about what happened with this USCIS officer, about why you didn't appear in court. She also indicated that she was going to file a separate brief because you have 30 days to appeal, or 33 days if it's mailed. And you don't have to file the entire brief at once because appeals are quite the process. But you file what's called a notice to appeal, and that kind of preserves your ability to file the rest of it. So within 30 days, you really don't have to file the whole thing. But if you say you're going to file a brief, you have to file a brief or it's getting dismissed. So that's one of the reasons the appeal got dismissed. It was filed on time, but it was dismissed because, number one, what was I just saying? Because you didn't file the brief. But it was also dismissed because for the very same reason that the first one ended up being denied. Although there was a sworn statement about this USCIS officer, the attorney didn't talk about what the previous attorney did and how he didn't provide effective assistance of counsel and didn't file the bar complaint or why they didn't notify counsel, and again, didn't show prejudice. Basically, these two attorneys kept telling her, it doesn't matter. Your relief doesn't matter. Until your case is reopened, it's no relief from removal. and that's wrong. If you have no relief from removal, you're not getting your case reopened. That's part of getting it reopened. You have to prove, because otherwise, why would the court reopen your case if they're just going to deport you anyway? Why would they waste court time? That's not the purpose of it. So she files this appeal, and unsurprisingly, it was denied in 2012. And then the reason the lawyer gave her was exactly what I just said, that you don't have any grounds to reopen the case. You don't have any relief from removal pending. I can't help you. And, she could have, but I think this lawyer just messed up. So the client, again, immediately started looking for legal help. And this time she was referred to her second paralegal, and this person's name I'm going to use for a reason. Some of you watching this may have heard this name before, Arlie Lewison. And that I'm going to actually post it in the comment, because this person, if I've actually gotten other calls about this guy. He, in 2019, was indicted for submitting over 1,800 fake applications for over 1,000 people. That's a lot of fraud. And fake applications, not real applications, or applications that just had no evidence to back it up. And if you've been a victim of this person, you might not even realize it yet, because they're still churning through those cases. I haven't looked lately on what's happened with his indictment, but he was arrested. I don't think the case is over. I know whenever they have these big fraud cases, it can take years. So if you have a case with him, you might want to switch over. And if you stop taking your calls, that's why. But the reason she wasn't aware really of the difference between the lawyer and the paralegal, but a friend referred her to him. She said he came to her church. I'm being informed that he died. I'm not positive if he died. I will look, but whether he died or he's either died or he's in jail. I mean, that it's one of the two. Because his case, he would have probably taken a plea. But either way, even if he died, you might still have some case pending with him. And he's not, by the way, unfortunately, he's not the only one out there that does things like this. So you need to really, again, make sure it's an attorney. But the reason that they trusted him was that he went to their church. He spoke about immigrants being abused or being victims of domestic violence. And he had helped some people that were able to confirm the help. And he said that he was going to do it for free. Now, anyone who's going to do something for free, especially what he ended up was allegedly doing for her, which was filing a VAWA application, which is not a small thing to do. Nothing's free. Nothing in life is free. Nothing that's worth it or that's good in life is free. And there's usually a catch. And he said to her when she questioned it, look, I want to get my name out there. I want to help. I want to help people like you, and I want to get my name out there. But still, that's still a lot of work to be doing for free. But this was the first person that she met with who actually listened to her about her husband and what she had gone through with him. So she had a little bit more faith. So she met with him in August of 2012 first. And so very shortly after the appeal was denied. And she explained exactly what she did with the other attorneys that she had met with, all the things that had happened. And finally, they talked about the abuse. And he said, well, you know what? We can get you a green card based on being the abused spouse of a U.S. citizen through what is called VAWA, which stands for Violence Against Women's Act. I always make sure to say to all our men out there, it applies to you just as equally as it applies to women. It's just called the Violence Against Women's Act. So she said, okay, let's file the VAWA. He files. Now, I should also, before I get to the VAWA stuff, another thing that's important is that this entire time, my client thought that her case, that she didn't have an order of removal. She thought the case was just closed. If you've watched my other videos where I talk about administrative closure versus dismissal, it is versus an order of removal. Those are very different things. When a case is closed in the immigration sense, or it's administratively closed, it means that you still are in removal or deportation proceedings. So if you left the country, you're technically deporting yourself, but you don't have a future court date. You're just not on the calendar. At any time, your case can be recalendared by you or by the department. The department would probably do it if you got arrested or something or committed fraud. You would do it if you ended up having, relief from removal later on. A dismissal or termination, those two terms are used interchangeably. That means that your case is completely out of court. So no more removal proceedings. No removal order because your case was dismissed. You can have your motions or your appeals dismissed, but that's different than having your case dismissed. And then, of course, an order of removal also means that you don't have future court date, but you have an order of removal, which means ICE, Immigration and Customs Enforcement, may or may not enforce against you. With this administration, she was not a person who would have been targeted with no criminal history. And they didn't even find fraud in the marriage. It was just that it didn't go great. And then, she had to get away from him. So he filed a VAWA for her and with the green card application. And the first one was denied in 2014. Because he listed, now when you file for a VAWA, or any of the categories where you're in an abusive situation at home, in order to protect you, if you have a safe address, you can mail it somewhere else so that your abuser, because you might not be able to get out of the home, so your abuser doesn't know you're doing this and then put you in more jeopardy of your safety in more jeopardy. Or if you have somebody who is preparing the application for you, and yes, a paralegal or notario can fill out an application, like literally fill it out. They can't interpret what anything means. They can't tell you what to put. They can sit there with you and you can give them answers and they can fill it out. And that happens a lot. And you have to be very careful that the person is not interpreting what should be there as opposed to just saying, okay, what's your name? What's your address? Type of thing. So because when you have a preparer listed on your VAWA, all the notices, so usually when I file for a client doing a regular marriage case, not a VAWA case, unless they check a box, it's default that I get a notice and they get a notice. So we always get two notices. So we get the receipt notices, biometrics, interview, whatever. When you do a VAWA filing with a preparer on it, the preparer by default gets both notices. So because this Arlie listed himself as the preparer, and non-attorneys can list themselves as preparers, she didn't know why it was denied. And he said to her, so she called him and he said, no problem, we just have to refile. Didn't give her a reason, just we got to refile. So they filed a second one in May of 2015, and it took only 4 months for that one to be denied. And again, he didn't tell her why. He just said, don't worry about it, we're going to refile. Third one's filed with another I-45 in October of 2016. And this was the first time he didn't list himself as the preparer. As a result, for the first time, she received notices from USCIS. And what she received 2 weeks after he filed it was that she didn't establish a prima facie case. What that means is, the simplest way to put this is when you file your VAWA application, and this is specific to VAWA, they have a checklist. And they basically say, okay, did you put in proof that you were, for someone who's a spouse, filing based on a spouse, did you put in proof that you were married to a U.S. citizen or permanent resident? Okay, check. Did you put in some type of good faith marriage evidence? Check. Did you put in some type of abuse evidence? Check. And did you put in some type of good moral character evidence? Check. If any of those boxes aren't checked, they say that you didn't establish your prima facie case, and they give you an opportunity to submit more in those cases. But that's, I always describe to my clients as, this is the first hurdle. You have to establish your prima facie case for them to continue processing it. It doesn't mean you're going to get granted. All it means is that you've given literally one piece of evidence for each category, so they will continue to look at it, or to adjudicate it. So when she got that notice, she called Arlie again and said, well, what is this? What's happening here? And this was the first time he stopped taking her calls. And she was talking to her friends who had gone to him, and they were having the same issues. He wasn't answering calls. And that's when she finally got referred to us. And this was in late 2016. And this is where our saga with this client begins. So we said, okay, so she described to us the whole situation. And we said, all right. We looked at the case number, and we're like, it says a request for evidence was sent, or an RFE. And the client said, I didn't get the RFE. So we sent the letter to USCIS and said to them, can you resend the RFE? The client never got it. And we also substituted in as counsel. Then it took a year for them to send us the request for evidence, from the time that we contacted them to the time that we got it. Now, there is a due date on these requests for evidence, and they are usually a little more lenient with VAWAs, especially without a preparer listed. I was surprised and relieved for the client they hadn't denied it, but the fact was, all he did was file the VAWA application. He really didn't file any evidence, and that's why I kept getting denied, because he just was refiling the same thing over and over. And we actually knew that for a fact, because on the RFE, when we finally got it, it stated that this is, you filed a VAWA petition 2 times before with no evidence, and this is the same thing. You need to. So we did reply to the RFE within the time limit, the new time limit that they gave us. We made sure to have all of as much evidence as we possibly can. And she, unfortunately, I always say this with VAWA clients, unfortunately had a really good case. We were able to get all the evidence. And then there was a little bit of confusion, which got back to what the status of her immigration case was, her removal case was. Again, she kept using the word closed because that's what the other attorneys had used. And to us, that means something different than an order of removal. So the third VAWA case finally was approved after we replied to the request for evidence with all of the required evidence. It took only 5 months to get approved, April 2018. And I don't even remember if we knew the I-485 had been filed. We may have known about it, and that would have been fine. If her case was admin closed, we could have asked to have it terminated. 1 second, I just had a question. Can you please tell me about document required for naturalization? From Teha SG82 on Instagram. I can definitely talk to you about that type of situation. Not right now, because I'm just focused on this one case. But if you go to our Instagram bio page, our contact information is there. Please feel free to reach out. You could also send me a DM and we can help you with that. So I am taking, if you have questions about this case in particular, I'm happy to answer that. But otherwise, reach out to me privately about any other situation. So after the VAWA gets approved, shortly after, she gets a notice to go for her green card interview. So I go with her. And we get there, and I tell the USCIS officer, well, her case was administratively closed, the immigration courts. And she thought that it was I was like, it was either closed or terminated, because if the case was still closed, then we had to go back to the courts. Like USCIS couldn't give her a green card. If it was terminated, USCIS could give her a green card. With the order of removal, that's a situation we're not going to get into, because there's rare situations where you can get a green card with USCIS, but it's really complicated. So we're not going to go there. But what was very strange was that the USCIS officer at the green card interview said to us, well, it's not really clear what happened. He's like, I think she has an order of removal, but I don't have the order of removal in here. I don't have an administrative closure order. I don't have a dismissal order. The file was just incomplete. Shocking. That happens, unfortunately, way too often when I go to these interviews, but that left us confused. So in order for me to find out what the deal was, I had to do a request to review her file with the immigration court. And then I actually had to go there in person. I sat down with her file that the immigration judge has, and I went through it. And this was in July of 2018. And that is when I learned that she had this order of removal in absentia from February 2011. Nothing had ever changed. And so once I found that out, I said to her, okay, now we need to file an appeal. Your case is with the Board of Immigration Appeals because it was appealed. And it's always where your case was last. So if you filed an appeal and they don't send it back to the judge, which in her case they didn't, that's where you file it. So we had to file this appeal. Well, sorry, I wrote appeal, and that's why I'm saying appeal. It wasn't an appeal. We had to file a motion to reopen with the Board of Immigration Appeals, which you can do. And we had to do it based on the ineffective assistance of the two attorneys and then the two other people involved engaging in the unauthorized practice of law. And I'm going to quickly review again, because this is important. In order to get a motion to reopen based on ineffective assistance of counsel granted, you have to show that it was fundamentally unfair due to deficient representation that you received, which prejudiced the outcome of your case. And these requirements that I'm about to repeat, you don't need to be perfect. You need substantial compliance, because sometimes you can't comply, as is the case where you have someone engaging in the unauthorized practice of law. You can't file a bar complaint because the bar only deals with disciplining attorneys. So you need an affidavit detailing your agreement with previous counsel, in this case, counsels and non-counsels. You have to, again, inform or notify the prior counsel that you're alleging that they did not provide you competent representation. You have to give them some time to respond. And then you have to file a complaint with citing ethical or legal violations, or if you haven't, you have to say why. So this is where that comes in. You can't file a bar complaint against the two non-attorneys, but you still have to notify them and give them an opportunity to respond. And then you have to show, which is the most important, well, they're all important, but you could do the first three things almost anyone could probably do in that situation. You have to show that you were prejudiced by the actions or inactions of counsel. Meaning, again, you have to show that if they would have done their job properly, or the way a competent attorney would have done it, then your case would have been reopened because you are eligible for relief, or your case would have been, the appeal would have been granted. We had those layers. Now, talked about at the very beginning, we had to peel through the layers here. We couldn't just, if we would have just focused on our Lee, on what he did, and just claimed, well, he wasted all these years of her life just filing these applications without evidence, we would have never had our motion granted. So we had to go through each person that she met with. We had to explain for each of them all those 4 requirements. And this was quite the appeal. And then, of course, we couldn't notify the alleged USCIS officer, because we didn't know, we had no contact information. We didn't even know if that was his name, the name we had. The prejudice that we couldn't file a complaint for that reason, and he wasn't a lawyer. The prejudice we showed is that he told her not to go to court, and she didn't. And had she gone to court and had proper representation, if she would have came to me then, I would have told her, this is an easy one. We file an I-751 waiver case. An I-751 waiver based on a marriage that was entered into good faith, and but that you were the victim of abuse by your U.S. citizen or permanent resident husband. It would have been an easy case to prove back in 2011. As the years went on, it obviously makes it harder because evidence gets lost, but we have to explain all that. So that was never done. The prejudice back then, it wasn't done. So we showed all of that for the first person. Now we get to the first lawyer. We showed that we notified him and that we filed a bar complaint. And the bar wrote back, and we also had to include, we had to give them time to respond and the attorney. And the bar said, well, we'll let the Board of Immigration Appeals deal with this because we don't know that much about immigration. And that is very true. Immigration is a very strange area of law. It's very complicated. And the state bar doesn't really deal with immigration since it's federal. So they don't know that much about it. And the BIA does have a way to discipline practitioners. But we also had to say that this first attorney should have asked her about her relief from removal, should have followed the ZADA requirements. And again, she would have been eligible for this I-751 abuse waiver. She also would have been eligible for VAWA. I mean, she could have just done VAWA. And there's also VAWA cancellation, which is another thing. It's similar to VAWA, but it involves there's slight differences, which I'm not going to get into right now. And then the second lawyer was very similar, that we really similar to the same thing that we did for the first lawyer. But we had to add that she didn't include how the first lawyer failed to properly represent her. And that we also had to add about the fact that she told the BIA she's going to file this brief and didn't, the separate brief. And then finally, the second paralegal, which was our Lee, we actually tried to notify, and the mail was returned. The second piece of mail wasn't returned, but he never responded. And then we had to explain how he should have never filed the all these repeat VAWA applications without any evidence, and he should not have filed the green card application all that whole time, knowing that she had an order of removal. And if he didn't know she had an order of removal, he should have known she had an order of removal before he did anything. So we had a really detailed affidavit from her explaining all of this. And then comes the last piece of the puzzle, well, the second to last piece of the puzzle, with the ineffective assistance of counsel motions, which is called equitable tolling. What that means is that there are certain time and numerical limitations that the law says you have to file certain motions or appeals. And I mentioned earlier, 30 days for an appeal, 90 days for a motion to reopen. So this motion to reopen, number one, you're only supposed to get one motion to reopen. And there was already one filed. And number two, it's supposed to be filed within 90 days. 90 days would have been back in 2011 when it was originally filed. And now we're in 2018, 2019. So I think I said, I think I said when I was in the court in 2018 reviewing her file. So yeah, we're in 2018, 7 years later. And if you recall earlier, I kept saying immediately, she immediately did this, she immediately did that. You have to show that two things, that your constitutional rights were violated because you didn't get due process due to the attorney's conduct, and that you exercised due diligence during the period that you're seeking to toll. So if you whether or not you filed the motion in the 90 days, if you're outside in the 90-day period and now you're filing a motion to reopen, you have to show that the entire time past that 90 days, and arguably even within the 90 days, that you've taken every step that you can take or that you knew to take as a person who's not an attorney to fix whatever problems happen. And in this, you never know how they're going to react, the BIA, especially when you have a case where it's been now, by the time we ended up filing the motion, it was 2019, but there was a reason I'll get to in a second for the next pause. But the fact of the matter was that every time that she acted within the time periods every time, and then as soon as she realized something was not right, she didn't just wait. She didn't wait even a little bit. She immediately started to look for more help, got more help, and we showed that all along the way. If she had waited 2 years after the motion to reopen or the appeal was denied to look for the next person to help her, that may have doomed her case. Yes, the judge can also open it sua sponte, which means on their own accord. So the judge can say, this is such a disgrace of what happened here, I'm going to allow the reopening. But they are supposed to conform to the law. So, it's not there's no guarantee that they're going to do that. But the one thing that this client really was really good at was following through on her case. She didn't just wait, and she didn't just sit back and let things happen. The time periods where she was waiting was when things had been filed and she was waiting for responses, which is normal. And then, of course, the last piece of the puzzle is proving eligibility for relief from removal, because you can prove all the things I just said, but if you have no relief, again, they're not going to reopen your case just to then issue you an order of removal or deportation. So you got to prove you're eligible. And by that time, the VAWA was approved, so we included that copy. And then we had to fill out a new green card application. We didn't file it with USCIS yet. Well, it's really with the court. When I say USCIS, you file the filing fee with them, and then you send the original to the court, because ideally getting your case transferred from the immigration court to USCIS can be a nightmare. I know if my clients out there are watching, who I have a few currently going through said nightmare. Their case was dismissed early, like a year ago, almost a year ago now, and it's like getting their case transferred is impossible. USCIS doesn't have it. Court, it's a nightmare. I've had this nightmare before. Eventually, it gets transferred, or you have to decide to withdraw and refile. But again, that's for another time. So we had to basically we had to really do the entire green card application, just not file it according to the procedure, because we had to show she was eligible. And she had no criminal history, no other inadmissibility. She entered with a visa of her VAWA. It doesn't matter. And we had to do that by submitting all the evidence that we'd submit with the green card application. Now, in 2019, we had a different president. And at the time, we weren't sure what was going to happen, because when Obama was president, they were, especially with the VAWA clients, they were reopening cases a lot, especially ones who went through what this client did. But when Trump became president, a lot changed. And we could have filed this two ways. We could have just filed the motion to reopen with the Board of Immigration Appeals, and then the Department of Homeland Security would have had an opportunity to oppose the motion or not oppose the motion. They could have even joined it if they wanted. But in a case like this, where we felt very strongly it was going to get granted and that DHS would agree, what I did was I filed, which now is commonplace with the Biden administration, it's called a request for prosecutorial discretion. And in this one, I said I had to actually write the entire motion to reopen first. I had to explain it to them. But basically, I said that I wrote the entire appeal, had the green card application, and I contacted the Department of Homeland Security, found out who the trial attorney was. I sent the request to them to join the motion, and that was in April of 2019. Now, about 6 months later, maybe a little longer than that, what happens? COVID. Now, it was taking them they were already backed up with appeals. So we weren't hearing anything. And then COVID happened, and I was just like, this is going to take forever now. But in April of 2020, I heard back from the Department of Homeland Security, and who agreed to join us on the motion, which is awesome. Because again, this was a lot that had to be explained and that they had to agree. And I might say 2 months is a reasonable period to find a new attorney. The BIA can turn around and say, no, there's no guarantees here. So having DHS join us on the motion is almost a guarantee that they're going to reopen the case, and they're not the ones who make the ultimate decision. In this case, it was the Board of Immigration Appeals. So we file this thing. So I get the letter from the Department of Homeland Security and file with the BIA the motion to reopen in May of 2020, right in the heart of COVID, right when my wedding was supposed to happen and had to be moved. We all were in turmoil then. And then we waited and we waited and we waited. And this whole time, my clients, I gotta say, I know you're watching, you were incredibly patient and understanding and trusting, because especially with what you went through, I can understand trust issues. But you waited almost 3 years for the Board of Immigration Appeals to grant the motion to reopen. And we were so excited when it happened. She found out Friday. I work from home Fridays, so I didn't have it. I was like, I can't say anything till I read the order. And I do have the order now, and I read it. And it was we contacted the BIA to make sure that, what's happening. And they said everything's fine. They're just really backed up. She was back and forth with her congressperson, because there's any congressperson, like all of your congresspeople, they have a person in their office that's a USCIS liaison, and their job is to help their constituents who are having issues with USCIS, and their congressperson tried helping, and it was like nothing. It was just stalled, and we couldn't do anything. And she was kind of stalled in her life, like just waiting for this thing. So we finally got this approval, and what the grant says is that they reopened the case and they're remanding it back to the immigration court, which we would have preferred it to have been reopened and dismissed, but the Board of Immigration Appeals rarely does that. I don't even know if in this situation if they could have outright dismissed it without sending it back to the court. Either way, they sent it back to the court. So what our next steps are, right after I finish this, I am going to reach back out to the trial attorney, and I'm going to ask the trial attorney if it will be quicker for us to stipulate, like they can agree with, like they can, another part of prosecutorial discretion is they can stipulate that she should get her green card. So we have to file the green card, properly file the green card application. And then instead of waiting for a court hearing, they may allow us to, they may agree she's eligible, and it's called adjudicating on the merits. Basically, they sign off on it, and then we send it to the judge to sign off. The other option is to have the case dismissed outright. And if the case is dismissed, then we file the green card application with USCIS, and we wait for the green card interview. Or they could approve it without the interview, which is happening a lot these days. Her case is complicated, so it's possible they'd call her in for an interview. I don't think it will take very long, this type of interview, but again, their old file was wrong. So I could see that happening because they confused themselves. So I have been speaking for almost an hour now. That's part of the reason I said I'm breaking this case up. I'll update you when, barring everything going as it should, when this client gets her green card. But, this was an incredibly interesting case, very difficult. There's a lot of lessons to be learned, which I would like to recap at this point. First and foremost, make sure you only hire a licensed attorney for any legal work, especially immigration. And remember, every attorney is registered with their state bar association or a state bar association, because it's federal law, and you can check with the bar that this person is licensed. Number two, nothing in life is free. You should definitely be wary when somebody offers you something for free, especially something that normally costs thousands and thousands of dollars. Number three, don't give up. Don't give up on yourself. Don't sit back and wait. You got to keep pushing, and you got to keep trying. I know that this client deep down felt that something was wrong, that her case was not handled properly, because she never gave up. She kept pushing. She kept, she did what a lot of people do, which is ask friends and family for referrals. And that's usually a good source to help you find someone. And as soon as she started to get that feeling like something's off, when people stop taking your calls or responding, that's a good sign right there. But a lot of these forms of relief, they have time limits. And if you miss the time limit, then you need to show that you are actively trying to do something within that time limit. Otherwise, no matter how much relief you're eligible for, it won't matter. And the last lesson to be learned is that, patience is a virtue, and it does pay off. And I applaud this client for really being patient with this case, because I told you, we first met with her in 2016. And it took so long because we had to wait for the request for evidence. Then we had to wait for that to be approved. And then we had this green card interview, find out other information that was confusing. We had to get permission from the court to go read that. Then I had to write the appeal, which was probably yay thick, and do the green card application. And then I had to contact the Department of Homeland Security and wait for them to answer. And then finally had to file the appeal or the motion to reopen and wait for the BIA to respond. So all in all, she has been waiting 12 years for this moment. It's almost 12 years to the, it was almost 12 years to the day that it was granted, that she first was ordered removed, to the day that her motion to reopen was finally granted. So, you know, I know people call me all the time, how long are things going to take? Why is my application taking so long? What's happening? And I never have great answers because I don't know their inner workings, and they don't tell me. They don't tell me anything different. But I'm able to tell when things are pending. I'm able to tell when things are done right. We never send anything incomplete, so we're never really that worried that we miss something. But it's getting worse, the wait times. So be patient, and if you're confident that you have competent representation, a competent attorney, then you should be in good hands, and you can sit back and not worry too much, as hard as that is. So I want to wrap up because it's been this is probably one of my longest notable approvals, just because again the facts here are so important. I really wanted to go through that slowly and explain, because we have people all the time trying to reopen their cases come to us, say, well, my lawyer didn't tell me this, my lawyer didn't tell me that. That, unfortunately, is not the end of the conversation. That's the beginning. So to really understand what the requirements are, hopefully this video helps with that. So congratulations to my client. We are very excited for her. Like I said, I'm going to reach out to the attorney, find out where we're filing this green card application, and get that going for her so that she can, after all these years, get her green card and not have to worry. And then she'll be eligible. I do believe he was a U.S. citizen, so she will be eligible for citizenship 3 years after she gets the green card. Getting a little ahead of ourselves, I'll talk about that again. But like I said, this was one of those, sometimes with my job, it can be difficult because I know, even when I know I'm going to win something, it can take years to get that satisfaction of winning. And it can be real frustrating along the way, but hang in there, because everyone is your case. It will get to your case eventually. And again, if it's done the right way, you shouldn't have any problems. Well, you shouldn't have any problems. Immigration, they make their fair share of mistakes. I fix a lot of them, but that's okay. I'm here. I'm here for you. If you or anyone you know, the situation sounds familiar, or you want help with any of your immigration matters, if you're on YouTube or Facebook, our contact information has been scrolling across the bottom of our screen. On Instagram, if you go to our bio page, you'll find it there. You can also DM us on Facebook and Instagram, LinkedIn. We're there too. Any way you want to contact us, we're here for you. Whatever is best for you. So that is, I'm exhausted now. That is all today for notable approvals. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching, so you don't miss any of our future lives, including an update on this case when that day comes. I know I'm going to be super excited for this client when that day does come. And if you found this video to be helpful, or know someone who has, and I really think there are a lot of people out there who don't understand ineffective assistance of counsel, hit that share button so that people can understand, hopefully, a little bit more. I hope my explanation was clear. And if you do have questions, of course, about it, please feel free to reach out. So that's all today. Thank you all for watching and hanging in there with me through this long fact pattern. I hope you got something good out of it, and have a great day.